All right, so we have participants rolling in. We're just going to wait a few more minutes. Thank you everyone for joining us today. We'll start in just a few as everyone comes in. My name is Ashley Artiles from Affinity Management, and with us today we have Alessandra Stilvelman with Eisinger Law and Gary Porter with Affinity Management. Again, we're going to be waiting just a few minutes for folks to keep rolling in. Thank you for your patience. Okay, so to be fair to everybody's time, I think we should go ahead and get started. Again, my name is Ashley Artiles from Affinity Management. I want to thank you all for joining us today. With us, we have Alessandra Stilvelman from Eisinger Law and Gary Porter from Affinity Management. Alessandra, why don't you take a few moments just to share a little bit about you before I go into our disclaimer.
It would help if I unmuted myself. Thank you, Ashley. Thank you everyone for joining us and to Affinity for partnering up with us to do this webinar. My name is Alessandra Stilvelman. I'm a partner and shareholder at Eisinger Law, and I'm board certified in condominium and plan development law. I'm originally from Brazil, and I speak Portuguese and Spanish. I've been with the firm for about 11 or 12 years now, and we specialize in representing condominium and homeowners association and co-ops. So this is our niche, and I'm really big on education and really glad to be able to do this and to have so many people here. So thank you.
Thank you, Alessandra. Gary, do you want to share a little bit more about yourself?
Sure. Good afternoon, everybody. Thank you for your time today. My name is Gary Porter, Regional Director with Affinity Management Services. We're super excited to spend the next 2 hours with you, but just a quick overview. We specialize in community association management, HOAs and condominiums, and we are in Miami-Dade, Broward County, and also Palm Beach County. Thank you, Ash.
Thank you, Gary. So really quick, I just, I'm sure you guys know this, but we always like to reiterate it. This is a disclaimer. This is by no means legal advice. So no legal advice at all. This is just Alessandra and Gary sharing their expertise on the topic. So the information contained in this webinar is for informational purposes only, and it is not legal advice or a substitute for legal counsel. Just go to the next slide.
Yeah, no, I'm trying. I have so many.
I just wanted to remind you all really quick. This is also not for state credit. So nobody will receive, a CE credit or a certificate. This is, again, just for educational purposes. So for a copy of today's slides, you guys can email Josh. He is great. He will answer very quickly. jcole@eisingerlaw.com. And he will go ahead and send it out. And he also put it in the chat for anybody that didn't have a chance to write it out. We're going to just let you guys know, again, this is a webinar, so you're not able to raise your hand, but you are able to ask questions. So just so you know, at the bottom of your screen, you see where the Q&A is, right next to where it says chat. You're able to put in your question. So you navigate to the tool panel, and then there's a dialog box. Alessandra and Gary and myself will do our best to answer all the questions within, a good time frame. Again, this is not legal advice, and we will do our best to answer all the questions that pertain to this subject.
Okay.
You guys met Alessandra and Gary, so Alessandra, why don't you take it away from this point?
Okay, great. So this is a really interesting topic because it's something that we get asked a lot about. What exactly is the role of management versus the attorney versus the board? And a lot of times it depends. And I've really been wanting to do a seminar like this because I think there needs to be some clarifications. And I think that board members and managers also need to understand a lot of the dynamics to be able to operate and to function properly. So we're going to start with the basics. We're not going to do a lot of legalese, but we'll have a lot of interaction and stories. And as Ashley said, we'll be doing a lot of Q&A as much as we can during this. If it's relevant, we'll answer it right away. I see a few hands up, but we're not going to actually allow you guys to talk. So if you have questions, if you can put it in the Q&A. So Florida statute define what a community association management means. And it's just reading from the screen, any of the following practices requiring substantial specialized knowledge, judgment, managerial skill when done for remuneration, and when the association or association served contain more than 10 units or have an annual budget or budgets in excess of 100,000. So here you see a few examples of the role of management. So controlling and disbursements of funds, preparing budgets or other financial documents, assisting in noticing or conducting of association meetings, determining the number of days required for notices, determining the amounts due, calculating votes, completing certain forms, drafting meeting notices and agendas, calculating and preparing certificates of assessments and estoppel certificates, responding to it, negotiating monetary or performance terms of a contract, drafting pre-arbitration demands, coordinating or performing maintenance for real personal property. So one of the issues that comes up a lot is that management companies won't have a specific LCAM assigned. There are certain provisions, and we're going to talk about this in the next few slides, where certain tasks can only be performed by a registered manager. But a person who does clerical or ministerial functions with direct supervision of a registered manager doesn't necessarily need to be licensed. So that's an important distinction to keep in mind. Okay, so, and Gary, feel free to jump in if you have anything to say about any of these, but we'll get to the fun stuff in a second. For condominiums, managers obviously can't get kickbacks, solicit kickbacks, or anything of that type. And there are specific provisions of what needs to be included in a management contract. So the management contract has to specify the services, obligations, and responsibilities of the management, how often each service, obligation, and responsibility will be performed, the costs incurred in performing of such duties, which is going to be paid by the association, and specify a minimum number of personnel to be employed by the management company, disclose financial ownership interests of developer or board members regarding the party contracting to provide the management services, or to the party, regarding the party contracting to provide the management services. So the statute is very helpful because I've seen a lot of management contracts that don't necessarily include all of this, not affinities, but I've seen others. So let me go to the next slide. I don't know why it doesn't let me. Maybe because other things have gone on. Is it moving for you guys? Am I frozen?
You're not frozen, but it's not moving.
Oh, okay. I'm like, wait, why is nothing happening here? Oh no. Oh, there we go. Okay. Let me just, okay. So when it comes to HOAs, there's also a statute that deals with management contracts, and it's not as specific, but it does provide that if you're going to have a contract with a manager, and if it was made by a competitive bid, then it can be made for up to 3 years. Now, a competitive bid is required in the HOA context if the amount of the services, for instance, the management services, are going to exceed 10% of the total annual budget of the association, including reserves. For condos, it's 5%. So that's a good distinction to keep in mind. And I don't know why my computer, I think because I'm sharing the screen. I apologize for the technical difficulties. Usually my partner does the screen sharing, and there we go. Okay, so there was a Florida Bar advisory opinion in 2015, which clarified a prior 1996 opinion, which talked about what activities are allowed by community association managers versus those that need to be performed by the attorney. A lot of the controversy that I hear often is from board members that ask managers to perform services that really should be done by the attorney. They want to save on the legal fees. They know that the managers are educated and deal with this on a day-to-day. So they try to just get the manager to answer the question. And the problem with that is that those managers may be partaking in the unauthorized practice of law. And so there's been a lot of discussion about this in the last few years. And in 2015, the Florida Bar came out with this advisory opinion. And they determined that the activities that you see listed on the screen do fall under what an association manager can do, and it's allowed. So they can change a registered agent and file the annual report, draft certificate of assessment, second and first notices of election, draft ballots, written notices, board meeting notices and agendas, affidavits of mailing, modify limited proxy forms promulgated by the state, and draft a limited proxy form. And I have a little asterisk next to those because that's further clarified, and the advisory opinion says it's based on the circumstances. So draft documents for associations right of first refusal or right of first refusal on a sale or a lease is also one of those that depends on the circumstances. Okay, so what is prohibited? A manager should not be completing the frequently asked Q&A form. They shouldn't be drafting claims of liens or satisfactions of liens or notice of commencement form or notice of termination of the notice of commencement. Determining timing, method, and form of giving notice meetings, that's something that should go to the attorney based on your governing documents in the statute. Determining the votes necessary for certain actions, which would entail the interpretation of statutes. Sorry, I see a typo there, and the rules. And answer community association questions regarding applicable law. So those are things that obviously we look at this now, we're like, yes, that should go to the attorney. But Gary, do you have experience where you have board members that ask for legal advice, and how do you handle that?
Yeah, absolutely. It's more common than it's not nowadays, especially with the governing documents. I mean, as the manager on site, we need to be really well versed with the governing documents for the association, and it's pretty black and white. But at the same time, we're still not allowed to interpret that governing document, right? So though we can read it and we have an opinion, we still recommend that the board partner with legal counsel to determine what the attorney's opinion or interpretation would be on that specific item within the document. So we definitely try to push back professionally and ensure that we get the experts, legal counsel involved to ensure that they're getting the right feedback.
And that's really important for purposes of protecting the board members, because you need to go to the proper professional in order to ensure that you're complying with your fiduciary duty as a director. And the way to do that is you seek the advice of the professional in each field. So you go to management for management inquiries, and obviously they will have certain experience to be able to answer certain questions, but the law is changing all the time. The statutes are changing all the time. And managers are not required, like attorneys, to stay up to date with every aspect of the law. So you want to make sure that you go to the right professional when you have certain inquiries that are legal related or management. So it gets a little bit more complicated, as you guys probably know, because there are certain things that, for instance, the limited proxy and drafting certain amendments and phrasing yes or no questions on a limited proxy, those you have to evaluate it based on the circumstances. If it's really just changing the name and putting in a yes or no simple question regarding the waiver of reserves, the opinion found that management could do that. But if it gets more complicated, then it should go to legal. So, we always take the position that have your attorney draft that package, have them give you the information as to what is pertinent as far as your governing documents, the statutes, any applicable case law, and then have management implement it. And then you can go to management with those questions. But that's something to keep in mind. And this course or this lunch and learn is about how to manage your managers. And it's really important to understand the limitations of the professionals that are hired by the board. Unfortunately, you can't, at least I don't know of anyone that's a manager, an attorney, an accountant all in one, nor would I recommend that. You want the due process, you want the separation of powers, you want people checking on each other to ensure that everything is done correctly.
Alessandra, I couldn't agree with you more. We have a big practice in our firm to ensure that our budget meeting notices, annual meeting notices, and then also any special member meeting notices, we do have counsel involved in drafting those packages, because especially from a manager's perspective, when it comes to notices, we always think that it's a 14-day out, but the governing documents are different. Some of them might say it's a 30-day notice requirement. So ensuring that we're partnering with counsel can ensure that we're covered on all bases, and then also protect the board of directors as well.
Right. And I mean, especially with HOAs, I find the statutes when it comes to elections and meetings are really broad and defer to the governing documents. With condos sometimes, and then you have the issue of whether there's Kaufman language in the governing documents, whether the statute applies, to what extent. So it's a little bit more complicated than it appears on the surface. I always say this in the webinars that the favorite lawyer answer is it depends, but it really does depend. We look at a variety of different documents and different issues before we answer a question. Unfortunately, it's not always black and white where we can have a clear answer. So we have a question here as to whether any long-term contracts should be automatically self-renewing, management or otherwise, if not specifically canceled within a certain time period. So in my opinion, I think that I don't like auto renewals simply for the fact that a lot of times the board members, if they're new board members, they don't know that it's being auto renewed. They're not sure of the deadlines. At the same time, I know that a lot of vendors like the auto renewal because it ensures consistency and that you're covered. So it depends on who the management company is, what their reputation is, how confident you are that they're going to be able to provide the services that you are seeking. And I always recommend that you have certain time period where there has to be a notice from one party to the other or some kind of correspondence so that it can alert management or the board. Because it could be that you have a management agreement with a management company and you have a new manager on site or a new manager that's been assigned and they're not aware of the contract deadlines, management or otherwise. So they may not be able to keep track of, or they may not have had the opportunity to sit down and look at all the contracts to keep track of the dates. Gary, from the management perspective, what are your thoughts on that question?
I agree with you as well, and I do think it's good practice that on a yearly basis, contracts are in place for no more than a year, because it does give the association the ability to evaluate services and ensure that they have the right partner on staff. It's funny that this question came up because I remember as a sited manager at a property in Delray, their governing documents were amended that no contract was allowed to be more than a year. And they did that for that very purpose of ensuring that the association is protected and they can evaluate service, and should something come to light, they have the opportunity to move on. So great question.
Yeah, and I think I always like to give both parties an out. And when we get to the end of this PowerPoint, I'm going to talk a little bit about the psychology of relationships. And I think at the end of the day, you can have a great board and a great management company or a great manager that's assigned, and it just doesn't work out. For whatever reason, the personalities clash, they have different backgrounds, whatever the case, and it's just not a feasible relationship that you can continue. So you have to take that into account. Other provisions that we consider in management contracts. So you want to make sure that you have proper termination provisions with or without cause. You want to make sure that both of the parties have proper insurance coverages. So what I generally recommend is that each association check with their insurance agent to find out what is the proper limits. What are the requirements? Is this manager going to be on site or driving around? Is it going to be a portfolio manager? Does the management company have sufficient insurance to provide? Do you have D&O coverage for the employees? Are you employing them directly so that you need workers' comp? Or is it a management company who's an independent contractor who's then providing the employees? So all of that needs to be understood and spelled out in the contract. You want to have proper notice provisions of how notice is to be given, maybe limitations on spending. For instance, I know a lot of boards like to say, you know, management for anything under $500, management has the authority, if it's a budgeted item, to spend for day-to-day maintenance matters. But anything over that, it needs to be approved by the board at a board meeting. Indemnification and hold harmless, that's obviously very important for both parties. And that's something that we can usually agree on, but that's usually a provision that's modified in the management agreements just to make sure that it's fair and reasonable. And buyout provisions and non-competes. So let's say an association hires a management company and they don't work out. So now they want to hire Affinity. But they really like their property manager, but they want Affinity to come in and hire their property manager and be the management company on site. Now you have to consider, one, does the association have any non-compete provisions or any obligations to, or non-solicitation provisions in their contract with their old management company that's going to prohibit Affinity from acquiring that employee and utilizing that employee at the association's property? And does that employee have any individual non-compete agreements with their prior employer? So all of that needs to be considered when you're negotiating a contract, so that not only can you have the option to buy out the employee, but that the management company will agree to release the employee from their non-compete. A lot of times we negotiate the attendance at the meetings, what the board is going to require. Obviously, a lot of this is circumstance specific. It depends on the association, on the board. How early do they need their report before board meetings? How many site inspections are you going to do? Or who's going to be taking the minutes? Is it the secretary or the property manager? And a lot of these issues that sometimes are unclear will be in the management contract. So it's really important that the board members, new board members, take a look at your existing management contract so you can understand the dynamics and the responsibilities of management versus the responsibilities of the board. Gary, any thoughts on this? And I'll take a look at the questions. Well, if you have anything else to add.
Yeah, these provisions are actually crucial to the success of both parties in the agreement, in my opinion, because it avoids the option, or it avoids any ambiguity between the two parties, especially when you're looking at buyout provisions, non-compete, notice provisions, and attendance at meetings. It's funny that this is even on the slide because we have a new partner that is having a lot of meetings. And in the industry, it's standard to have one meeting a month, but one of our partners is having weekly evening meetings. And that alone can be a strain on, a community association manager and also the staff if anybody else on the team is expected to attend. So really spelling those things out in the provisions is important because it really sets the expectation between both parties, as well as the sited staff, to ensure that they have a quality of life.
Yeah. And I think what you said is really important. The whole establishing the expectations. I think at the end of the day, that's really, really important. The expectations based on what you guys have agreed to in the agreement, right? So a lot of times I review these agreements that are really unclear. They just say the management will manage. And I'm like, okay, well, what does that mean? What exactly are their responsibilities? Are they going to go to your property every day? Are they going to stay at your property and it's going to be the same individual? Are they sending someone to do inspections? I mean, we need to understand what that means. And with the evening meetings, I mean, I think we've seen as a result of COVID, Zoom is very popular and it's very convenient and easy to use. But it almost makes it too easy where, I think a lot of boards sort of just tend to assume that the manager is free at 7 p.m. on a weeknight. And it's not, they may have other associations, they may have other obligations, family obligations. Same thing goes for all the vendors. So obviously that needs to be organized and scheduled, and you need to know whether or not your manager is required to attend those meetings, how much notice they're going to need. And that all needs to be really talked and discussed and put into the contract. Sorry, I see a lot of questions and I've been talking, so I haven't followed up. Anything, Ashley, that we can answer related to this?
I've been answering them as they come in, but does the manager determine who is eligible to run for the board? That was something that you previously discussed in other slides, but.
Okay, so eligibility for the board is a statutory matter. So generally, management is going to have control of the ledgers. They're going to know if someone is delinquent as of the date of that the notice of candidacy is due, or for an HOA, if you're taking nominations from the floor, as of the date of the election, they should know who is delinquent and who isn't. They'll also know if there's any other restrictions. I mean, the issue is that one of the statutory restrictions on who can be eligible deals with criminal history and whether they've been convicted. And a lot of times that doesn't come up, and management shouldn't have to be responsible, nor do I think they are responsible for looking into that, nor is the board per se, unless someone is aware of that condition. And unfortunately, that usually only comes up when you have someone that's on the board, that's running for the board, that the other board members know has a history or are looking for a way to keep them off the board. Ultimately, the decision of an association, the day-to-day management, the major decisions at the end of the day, they're made by a majority of the board members. Now, the board, by virtue of contracts or of resolutions or motions at board meeting, they delegate those responsibilities. So, I don't think that, Gary, I don't think that managers are the ultimate yes or no. I think what I've seen is it's run by the board, and the board then gives the okay as far as the ballot and before sending out the second notice. But let me know if you've seen it otherwise.
No, I'm in total agreement with what you're conveying. I've even seen in the past that we've had a partner that wanted to put into the first notice for the 2 notice requirement that anybody that wants to submit an intent to run form needs to be an owner for at least 2 years. And we definitely push back, because it doesn't indicate that in the statute that you need to be an owner for 2 years. It just indicates that you need to be an owner. And then there's some associations based on government documents, you don't even need to be an owner. So we definitely partner with legal counsel when we have those type of issues, because there's a lot of creativity out there that people want to put into place to try to mitigate certain people from having the ability to get on the board. But what's your thoughts on that, Alessandra?
Yeah, no, I agree. We generally take the position that the statutory requirements are really the only enforceable requirements. If there's a lot of residency requirements in the governing documents, like the governing documents will say you have to live in the community if you're going to serve on the board. And we tend to take the position that those are not enforceable. The statute says who is eligible. They have to be a member or a director, and the governing documents will define who's allowed to be a director. So sometimes you don't even have to be a resident or an owner in order to be an officer or director. That's based on the governing documents. But any other obscure restriction, like you have to live there for a certain period of time, or you need to have been a resident or have owned, all of those tend to not be enforceable. And really, it's on a case-by-case basis, but we generally take the position if it's not in the statute, then it's subject to being challenged. And it's not worth it when you're going through the whole election to be making decisions that are going to open you up to liability, to an arbitration dispute regarding the election. Okay, hold on. So let me go to the next slide. So this is a little board member responsibility or manager responsibility. So as we've mentioned, obviously that's going to depend on the association and the contractual obligations of the parties. But generally speaking, bids for contracts, Gary, would you say that's management?
100%.
Yeah. And approval and signing of contracts, board responsibility.
Definitely the board.
Right. And just before we even get the question, board should approve all the contracts at an open board meeting, unless it's pending or proposed litigation or personnel matters. It needs to be at an open board meeting, and the majority of the board should be approving and then authorizing someone to sign the contract on behalf of the association. The approval of the sale, lease, transfer, occupants. I know that management normally is the one that undertakes the process, and it's specified in the contracts that management will assist with the background check, with the application. But then at the end of the day, it's a board decision. I mean, I don't feel comfortable with management, and I assume you guys don't give your managers the authority to do that either.
Oh, 100%. Our managers are not allowed to sign off for any proposal or any contractual agreement. That is definitely a board member responsibility. And great thing about technology these days, whether it's a board member or officer is living on site or they're working, we do have DocuSign, which can help, alleviate that issue and ensure that we do have a board member executing.
Yeah, no, absolutely. Preparing notices depends on the circumstances, like we discussed, depending on the type of notice. A lot of times, if it's an issue like a special assessment notice that needs to be specific as to the details to comply with the statute, then we recommend having the attorney do it. If it's something that has already been done or a board meeting notice, then management normally does that. And then every association has their own procedures as to what items get put on the agenda, and management works with the board, right, in order to come together with that agenda and set the meeting in regards to everyone's schedules. Responding to owner emails and calls, I think that really depends. Communicating with vendors, what's your position on that?
My position on communication with vendors really should be left in the responsibility of management. Especially when we're on site, we want to ensure that the communication is funneled in correctly. And, as we are responsible for executing the board's directives, right? So sometimes when you have a board member that may be involved or a very happy and excited unit owner that wants to be involved, sometimes the lines of communication can be blurred. And also the information can be misconstrued because we're not delivering the right feedback. So I think ensuring that it's funneled through management and management has the total autonomy with partnership of the board, but also just having the ability to manage the vendors, it's crucial and key to the success.
And keep in mind, and something I always say, don't put in writing anything you wouldn't want your mother or a judge to read, because a lot of times, in today's day and age, everyone's on WhatsApp groups, they're on chats, they're on emails with management and board. And if you're discussing board business, even though you're allowed to via email per statute, it still could technically be deemed an official record of the association, which may be subject to inspection. Or if there's a lawsuit with a vendor, they may ask for all of the association's communications or emails regarding that vendor. So you have to be very careful with what is communicated. And I agree, it needs to be channeled through management so that management is kept aware of what's going on, and then ultimate decisions be made by the board. One of the questions here, and I think it was in response to something that I mentioned, if there's an emergency, who can approve a plumber to fix a pump? Generally that's contractual. So your contract will say that management can spend up to X amount on day-to-day repairs, unless it's an emergency, at which point they will try to contact the board. And if they can't, they can do whatever they need to do in order to ensure the safety and protection of property and people. So generally that's contractual, and that should be in an association contract with management as to the authority to hire vendors. But there should always be a board member that's somewhat involved and on top of the day-to-day operations.
Cassandra,
Yeah.
what are your thoughts about, for an instance like that, we've seen in the past and we've recommended in the past that there either be an administrative or a procedural resolution adopted for emergencies. That way it clearly details that, either management or the board president has the authority to act on emergencies within an X amount of dollars. What are your thoughts on that?
I love it. I love resolutions. I can't see your head. You're going headless, Gary. So I love it. And I've been really liking resolutions simply because things get lost in the minutes. Directions get lost in the minutes. Procedures get lost in the minutes. The board may discuss it. And then if it's not properly documented or made in the form of a motion, 3 years later, no one's really sure who's supposed to be doing what. So the fact that you have a resolution that's spelled out and that the board members approve at a board meeting, that manager has a copy of and that the board has a copy of, makes it really smooth for new board members to transition, for new property managers to transition. I mean, it just establishes the procedures of your corporation. I mean, at the end of the day, the association is a not-for-profit, a corporation, but it runs just like a business. So you really need to be taking the steps to establish procedures or policies like a business would. And that's something that I think is one of the main issues that I see with associations and management issues is that where it's unclear who's doing what and and it's the expectation issue. So the board is expecting way more from management than the contracted hours allow for, or they're expecting them to make decisions that really the board should make, or to engage contractors, or to fix things that hasn't been approved, or that there's no money in the budget. So there's a lot of issues, and if you have resolutions and procedures in place, it's pretty clear and straightforward, and there's no ambiguity. So okay, so I see here, what would be the interpretation of delinquent past due 1 month, 1 day, 1 month? So Deborah, that depends as to what. So if they're past due pursuant to your governing documents at the date that it's due, they're delinquent. However, in order to be eligible for the board, they have to not owe anything to the association, any assessments or fines or any charges to the association as of the date that the notice of intent for candidacy is to be submitted in the condo situation, and then as of the date that nominations are taken in the HOA circumstances. Now, once someone is on the board, they can't be more than 90 days delinquent in order to stay on the board. And, that should be something that management should be monitoring as far as the delinquencies, and let a board member know, hey, by the way, you're almost delinquent, so that you're not automatically off the board. You need to pay off this amount. And I think that sometimes board members get comfortable, they direct management otherwise. If management doesn't know who to take direction from, you end up having a board member that's been delinquent way more than 90 days making decisions, and that could be it could be a problem. What else? Anything to say about that, Gary?
No, but thank you for clarifying that. It's great insight for those on the call.
Yeah. So how often should a board have a board meeting? It depends on your association. I have some boards that have so much going on because of those specific circumstances that they have to meet every week during a project or a litigation or something. Others meet every 6 months, or have a once a month scheduled board meeting, which I think is what I've seen works the best. They have it every month on the second Tuesday of the month. And so all the board members know to keep that date clear. But if they need to have intermittent board meetings or change it up every once in a while, then they can address that as the issue comes up. But because decisions should be made at an open board meeting, you should have them probably on a monthly basis. What would you say? Is that pretty average?
Yeah, 100%. Having a standardized meeting schedule, be it once a month, is great for not only to ensure that things are running smoothly within the corporation, but also for the membership, so that way they can have a good sense of what's going on the day-to-day as well. But there are associations, like you said, that have quarterly meetings, or sometimes it's just once a year, which is their annual meeting. So, but those associations that run best and allow the membership to really have a good understanding of what's going on, a monthly meeting schedule works out the best.
Great.
So, Sandra, I don't mean to interrupt, but a lot of questions are coming in, so I want you guys to be able to answer them. And we're talking about contracts. So can service maintenance contracts be ratified at a future meeting if the board is not meeting frequently?
It depends. I mean, I think that we usually take the position that the board should meet to approve necessary contracts, or at least big, large financial, or whether it's financial or if it's a big contract because it's controversial, right? Whether it's a material alteration contract, or if it's for something like cutting trees and the owners don't want the trees cut, it doesn't matter the financial amount of it. If it's controversial, it should definitely be done at a board meeting, an engineering contract. Now, if it's an emergency or if it's a time-sensitive issue, then I would say ratify it at the next board meeting. But just make sure that you have the consensus of the majority of the directors, so that when you go to ratify it, you're not going to have people actually challenging the decision that was done prior. So, the ratification is really for purposes of ensuring it's memorialized in the minutes and ensuring that you have everyone's official approval, but it should really only be utilized in necessary circumstances where you're unable to get that board meeting going.
Thank you.
Okay. I see a lot of questions, so I will try to get to them. I saw one about if the manager is not fulfilling the expectations, when to get legal involved. That really depends on the circumstances. I think there needs to be open communication at all times. I think a sit down with a manager. I mean, I've had an association that they did 100 days, and 100 days into that new board, they literally called every single vendor, including us as the attorneys, to have a sit down to be like, this is what we're happy with. This is what we're not. This is what we plan on accomplishing during the rest of the year. This is what we'd like to change. And then at least you have that open communication where if the board is happy, if the board wants something else, if you can deliver or you can't deliver, and maybe you just you're butting heads moving forward, but at least And if anyone that's out there that knows me, I'm very blunt, and I think that relationships tend to work when you're open and you're direct, and especially when this is a business. I know it gets personal because for us, we're professionals. This is our job. We're getting paid. For you guys that are board members out there, you're volunteers. The people that you're having issues with, or the other members on the board, they're your neighbors, they're your friends, they're the parents of your kids that live in the same neighborhood. So it does become personal, and it is hard to have, confrontational talks, but sometimes it's necessary in order to move on, because at the end of the day, the association is a business, and as directors, you have to act in the best interest of the association. So hopefully that answered that question.
Senator, if you don't mind, if I could jump in real quick.
Yeah.
I think the feedback that you provided was crucial. And if we take a step back and really look at whether it's your management firm or it's a or any other vendor, this really is a relationship, right? So it's especially when it comes down to your manager. And when I do sit down with board members and have to have that type of conversation, the first thing I ask is, have you spoken with the manager? And if they haven't, why not? This truly is a relationship, right? So your manager is on site. There's no reason why you shouldn't feel comfortable in having a conversation in regards to performance expectations. And if things don't change, we are certainly there, whether they feel comfortable or not, to have the conversation, to step in and mitigate that, because that's our role. We are here to support not only the manager, but also the board of directors. But if we really take a step back and think about things as a relationship, we should feel comfortable in having those conversations. And that association that did that exercise, I applaud them, because it does really show that they have that mindset.
Right. And what you said about the relationship, I'll reference later when we talk about the psychology of all this, but it's absolutely true. And I think that you have to take the steps necessary to figure out. A lot of times when I see board conflict with management, what happens is that the manager has several different board members giving them different directions, and they're not sure who to take direction from. And that's why in a lot of management contracts, you see that managers supposed to take direction from the president or somebody else that's designated, so that you don't have 5 different people telling your manager 5 different things. And then one person's going to be upset when their directive doesn't get done, or the manager didn't prioritize their project. So again, it all comes down to communication and discussing it together at a board meeting. Even though Zoom is being used a lot, I highly, there's something to be said about, I'm looking at you, Gary, like we're talking, right? Ashley, we're talking, as opposed to having a telephone conference or a Zoom with no video where you can't see people's reactions. You can't see if they're angry or upset. And I think that goes a long way too. You need to be able to read people and how they take your commentary to determine whether it's going to be a relationship that can move forward. So we did a few what ifs. And this is the board members are giving management different instructions that contradict each other. What would you do?
Alessandra, before we start that what if, I have one to kick it off. This is a question for us that happens quite frequently, so I wanted to just kick off this slide. Yep. What if the previous management company lays off an employee when the management contract term ends? Is the new management company able to hire them and send it back to the same HOA? I wanted to throw that to you because we do get that question a lot, and it's something that it'd be great to hear from you on the legal side of it.
So that depends, and that goes back to the whole buyout versus non-compete. So maybe that non-compete is not an issue anymore because that manager was terminated. Maybe it still is valid 2 years after termination, right? So maybe that employee still has a non-compete where whether they're terminated or not, they can't work for the association or anyone that management provides services for. Sometimes in the association's contract with management, it will have certain non-solicitation saying that that association cannot keep any of their employees unless there's a liquidated damage provision, which doesn't necessarily mean that you can always buy out the employees. So this is very contractual, and this is one of those issues where definitely have legal involved, to have them review the non-compete, the new management agreement, the old management agreement, and try to come to a negotiation. Some management companies are very willing to buy out employees, to work with the association if they want to keep certain of their employees. Others want to prove a point and they don't let the association, maybe it becomes personal for management companies too. Maybe the management company did so much for that association, the board just didn't see it and they're very upset and they have another position for that manager and they don't want to let that association keep it out of spite. And I see that a lot. So it's very circumstantial. Okay, so going back to board members giving management different instructions, I think we kind of covered that. Expectations are far from reality and contractual agreement of the parties. How do you handle that, Gary?
That's a great question, especially when it's the expectations are far from reality. I think us sitting down, myself and the respective manager, with the board and really understanding what it is that they're trying to accomplish or where the disparity is between the expectation, and just having a great conversation about how we can either meet in the middle or get to where they want. But does that require an amendment to the agreement, or does it just really require us to have a new alignment of expectations? But it does happen more often than not, especially in the portfolio world. You know, when you have a portfolio manager that's contracted to your association for 8 hours a week, but they really have the expectation of a 40-hour sited manager.
I see that a lot. And a lot of what I think boards don't tend to understand, which I see as a trend in the industry, is that, and I'm not sure if you guys do this, so please correct me, but I've been seeing a big trend where, you know, there's the payroll percentage, right? So it's something where the bigger management companies, it's not that you're hiring, the association hires the employee. It's the manager that has the employee. The association pays a management fee, and then the employee gets paid by the management a certain salary. And then there is a burden fee or a payroll burden on top of that, so that the management company can take care of the taxes, the workers' comp, the insurance. I mean, all the things that go into it. And every management company is different, which is why it's really important to look at those contractual terms.
Correct.
Okay. What if management is making decisions unilaterally?
So yeah, at least here at Affinity, we don't make unilateral decisions from a management perspective. Again, it goes back to what we discussed earlier, that you know, the board makes the decisions and we execute their directives. So unless our agreement indicates that the manager has the ability to spend X amount of dollars without board approval, whether that be for normal day-to-day operations, and it spells that out specifically. And we do have a partner that does a phenomenal job with that. They give the manager the autonomy to spend $3,000 without board involvement, and anything above that, it requires the board involvement. And if it's an emergency, it's $5,000. But again, those things are explicitly spelled out. So if we don't have an agreement that's explicitly spelled out like that, then we will be partnering with the board of directors for approval on anything, because that's the way it should happen.
Right. And I see, you know, that's why we started with a contractual provisions, because that establishes the responsibilities, the expectations. And, you know, I can't tell you how many board members send me the contract and say, no, just do what you think is best. Do what you think is best. And I'm like, well, no, you need to understand these provisions, because you're the one that's going to work on a day-to-day with a manager. So you have to tell me, do you want them to provide a board package? Are you going to require their attendance at every board meeting? And a lot of times the board has already negotiated the proposal and then just doesn't understand that those are strict terms, and the management fees is going to change based on how much responsibility the management is going to have. So you know, a lot of that plays together with the whole unilateral decisions. What one person may think is unilateral is really authorized in the contract. I saw a question here about if a management leaves and leaves a mess behind, which unfortunately I see a lot of when there's transition of management. There's a lot of management companies that tend to not cooperate with the transition. Maybe if they were improperly terminated, or maybe now the board is asking for documents that the manager never had, or the management didn't keep the official records. And it really depends. It's on a case by case situation as to whether to get legal involved. A lot of times you're going to spend more money with legal than it's worth it, in my opinion. Sometimes you just have to start from scratch. You get your new management company to come in and to help you out. You get someone that's qualified to assist in organizing everything. But once you terminate a management company or just any vendor, they're just not going to step in and do you any favors or do things that they should have done that they haven't. I mean, it's just human nature. When they're done, they've moved on, you guys move on. And unless it's just a clear material breach of the agreement or the association has a financial consequence as a result of it, I don't know that it's worth pursuing. And that goes to the whole management fails to provide records to owners, directors. I mean, keep in mind, a lot of times owners are asking for things that may not exist. Directors want things today, but if it's a portfolio manager, they may not be at the office where they have access to that document today. So there has to be a reasonable expectation of your manager and their responsibilities. I like to put in the contract that management has to respond to owner inquiries within a certain period of time, has to communicate an update to the board every month as to what's going on. And that way you don't get the board members getting emails from owners saying that management is ignoring them. You don't have management missing emails. A lot of things come into play here, but again, communication in my mind is the key to the proper relationship with any vendor.
100%.
Absolutely, yeah.
And I did see a question earlier about management being threatened by the owner and the association's responsibility. I don't know where it is, but this is I just figured out how to change the slide easier, by the way. This is something where there is a certain amount of responsibility on the association. If the association is aware that there's an owner or a board member that is hostile to other owners or to management or to staff or to vendors, because the fair housing law comes in and the harassment in the workplace law comes in, and there are certain protections. And I have an article in my website, a blog on this, because this was modified a few years ago. There's not a lot of case law in Florida, but it does say that the association would be responsible if an employee is being harassed and the association is aware of it and fails to do anything about it. So I do recommend that associations put a stop to that right away, send a cease and desist letter, explain to the owners they can't treat the employee like that. It needs to be there needs to be respect. And I know with the pandemic, at least, it's, a lot of the crazies have come out. We've seen a lot of issues with people that have lost their temper, that have cursed, that have threatened, and I'm hoping it will get better and people will go back to just dealing with human nature and being cordial and respectful to each other. But it does happen. Gary, do you have any experience with that, with managers being threatened and not wanting to come back to work as a result of it?
So we've definitely had experience with managers being threatened, and luckily enough, our staff is professional enough where they haven't felt that they don't want to come back to work. We always want to remind our managers, and we do that, remind them that we have the privilege of working in somebody else's home, right? But that doesn't mean that they should be treated like the doormat. So we do want to provide our managers with foundational support, and we encourage them to speak up. So that way we can, if they don't feel comfortable, then we can certainly step in and lobby on their behalf to the board of directors and find a solution to put that to bed. Because, especially when we take pride in recruiting the right talent. And we also take pride in having the board of directors feel that they have the right personnel on site. And so it truly is a relationship in a marriage, right? So we don't want to lose our staff, and I'm sure that the board doesn't want to lose the staff either. So working together to find a way to mitigate that is huge.
So this is a 1 hour webinar, right? So we're getting to our end. I know Gary mentioned 2 hours before. I just wanted to make sure what we noticed it for. Ashley, was it? I think it's 1 hour, right?
I'm not sure. I think it's 1 hour.
Okay. All right. Just making sure, because we're getting to the end, and this is one of my favorite parts. Full disclosure, I have a psych undergrad degree, but this is not very psych specific. And we were going over this on our dry run, and Ashley and Gary were like, wait, are you suggesting that everyone should have a psych degree? And that's not my intent here. I just wanted to point out that a lot of the conflict and issues I see as the attorney, because usually things come to us when it's already sour, right? Very often we get to review the agreement, and then we negotiate the terms, and then we'll hear back from the client with issues with management much later on, but it's already an issue. So a lot of what we see comes down to personality types, comes down to misunderstanding, not understanding how, or misunderstanding someone's intention. Maybe they said something that came out wrong. Maybe they're just more of an extrovert than an introvert. Maybe they're just loud and assertive, and the other person is more introvert and maybe is not going to interrupt you at the board meeting, but has really important things to say and is not getting heard as a result of the fact that they're not screaming over everybody else. There's a lot of different personality type and tests out there. I have a lot of fun with this because the more I learned about different people personality types and you apply it to your work life and your personal life, it could really, really be effective in just day-to-day situations. So it provides you understanding of different reactions and perceptions. And the next slide this is one of my favorite personality types. It's based on whether someone is assertive, compliant, or withdrawn, and if they're fear, anger, or image-based. And you kind of know what drives them. It gives 9 different personality types. No one is really one exactly. There's a whole coordination of it. But at the end of the day, it's really interesting to see. Oh, sorry, hold on, I went backwards. It's really helpful to understand who you're working with, what their background is, what their experience is. Maybe they don't write the email so well, but you can speak to them and get a hold of them via the phone. If you know their circumstances, it just helps with the relationship, and communication is key. So when you're dealing with vendors, especially with management, make sure you communicate, make sure you understand the personality types. This goes for personality types within your board. This goes to interactions between the owners and the board members, the owners and manager and the board. So, we're dealing on a day-to-day with people regarding the members' homes, their day-to-day operations, but we're professionals, they're living there. So we got to keep that in mind, as opposed to the members need to know that you guys are trained, we're trained to do certain things. So if those expectations are clear, I think it helps for a relationship moving forward. Apparently the webinar was 2 hours. Well, lucky you, it is only 1 hour because we're done. I'm sorry about that. But I can stay on and take questions. I know we have a lot. What do you do when you can't get minutes of meetings from your property manager? Again, I would say you have to inquire. You have to be clear as to whether or not they had the responsibility to take those minutes. Give them some time. I don't know what your circumstances are with that property manager, but I guess that depends. And ultimately, the property manager, if their responsibility is to draft the minutes, they should be drafting it and taking notes as they go. When it comes to minutes, I'm very big on, you're not putting every single detailed conversation that occurred at that board meeting. You follow your agenda items. So you take the motions, you take attendance, and then you do a motion a second, and you take a vote on what's approved. You can say that discussion occurred. You can say that there was some commentary or concerns about XYZ, but you don't have to put every owner and their comment, because then you're gonna have 5-page minutes that's really not that relevant. Let's see. Do you guys see any other questions here. Is it against the law for owners to curse or yell at other owners or employees? So that's a tricky one because it could be deemed harassment. It's not against any specific laws in the condo or HOA statutes, but it goes back to the basics of, you know, day-to-day interactions. If you go to a store and you start screaming at someone or at the vendor is going to call the police and say, get him out of my property. To the same extent, if an owner is intruding themselves in the property management office, if they're acting in such a way where the manager feels threatened, then you call the police, and that may be a criminal act, that may be an assault, that may be attempted battery. I'm not a criminal attorney, but I know that there are certain restrictions on that, but just yelling and cursing, I don't know if it would get to that point. Sometimes board members or owners go for restraining orders. And for that, you have to have a certain level of threat or fear against yourself and your well-being in order to qualify, and at least to report an incident. There's a lot that goes into it. So it's really depends on the circumstances.
Hey, Alessandra, there was a great question in the chat that I think needs your input on. It states that if all of the board members resign and there's no candidates to fill the board, what's next? Well,
I recommend you find some candidates. Otherwise, there needs to be a receivership, and it's going to get really expensive. You're going to have to go to the court. They're going to appoint a receiver. The association is going to have to pay the receiver's cost to manage the association, just like the board would. So, you don't want to get to the point where there's no board members, even though it's a volunteer position. There should be people volunteering to then coordinate the vendors, because at the end of the day, the board members are making the decisions, they're undertaking certain projects, but it shouldn't be to the point where no one wants to participate. I've gotten to some situations where we've gotten threats of everyone resigning, and I always talk my clients off the ledge because of the circumstances and the financial constraints as a result of that, and the financial complications. You can't just have no one running a corporation, right? So that's a problem. Okay.
I see a question here that I would like to ask you both. An association hasn't had meeting minutes for 3 years. Their property manager says she works on priorities and doesn't have the time to do them. What's your take on that, Gary and Alessandra?
I'll let Alessandra go first.
Smart man.
I usually take the bad cop. So I would say that's not acceptable, in the sense that the minutes, assuming it's a property management responsibility in the contract to take the minutes, then the manager should be typing up those minutes on a timely basis, so that when you get record inspection requests, or that you have a record, because it protects the board. I mean, the board decisions are made at a board meeting, and the only way to memorialize that is in the minutes. So it's really important. Maybe the minutes are not final. Maybe she can put in the details after, but there should be minutes being kept, because if you wait too long, everyone's going to forget and notes get lost, and then they don't get done. And then the association could be in violation of applicable law and be fined by the DBPR.
Thank you.
Gary, was where you were going?
Yeah, so I am in agreement with you that, first of all, that I can't even fathom an association not having meeting minutes for 3 years. But I do agree with you that that really is unacceptable, and it shouldn't occur. However, there is a secretary in an association. So if that is the case, then we would certainly hope that the secretary would step up and at least take the meeting minutes to ensure that the association is protected, because at the end of the day, those are corporate meeting minutes that should be kept on record for the purposes of not only ensuring that if a record inspection happens, you have those minutes available and you're not penalized, but also to ensure the continuity of the corporation, because if the board changes, they should be able to look back over those minutes and have an understanding of what has occurred in your meetings.
So there's a question here if there's a general rule on the estimate of management time needed to effectively run an association, if it's based on the association's budget, or if there's a range of fees.
I was just answering that one, but you
Oh.
got it.
Oh, sorry.
No, go ahead.
Do you want to answer that live? Because I just clicked off on it on the Q&A.
So there isn't a general rule, or at least how we do it at Affinity, there is no general rule. It is based on how much time you need, how much time the association needs. The budget does help, but there is no general rule as to, a property of 200 plus, it only gets 20 hours. No, there is no general rule. It all depends on if you're portfolio or if you're on site, and we go from there. Gary, Alessandra, if you want to elaborate on that.
Very association specific. I mean, depending whether it's HOA, condo, depending how big, how many units, how much work is going to be necessary.
Projects.
Right. Are they in the middle of their 40-year certification? Do they have to start it? Are they, doing a re-roofing project that's going to require substantial involvement from the property manager? I mean, a lot of these come into play. There is a question here about whether or not we would recommend having regarding an evaluation of the manager and getting feedback from owners and residents regarding their satisfaction. And, generally I'm very big on transparency. I think that the owners need to know what's going on, but at the same time, I think that could create more problems than assist. I guarantee you, if someone has a complaint, they'll make the complaint. But at the end of the day, I don't know that the owners really understand, or the members understand, what the manager's responsibilities are, and getting their feedback may not necessarily assist you, because you have to look at their contractual responsibilities. Maybe they don't like the personality, and maybe you already know that, and that's why you're asking that, because the manager's clashing heads with people. And that's something that I like to put in my management agreements with the management companies, that in the event someone's assigned to the property that the board is not working well with, or is not happy with their performance, that as long as it's not discriminatory, their basis for requesting somebody else, that they work with them, that the management company work with the board to bring in an employee that the board feels they can work with, and having that ability for the board to say, you know what, it's just not working out. We want to stay with the management company. We just need you to assign a new manager. And sometimes that's what it takes, because at the end of the day, and I went back to this Enneagram because someone asked to go back to the screen, but at the end of the day, it comes down to personalities. Maybe it's not a breach of contract. Maybe the owners are just clashing with the property manager, or maybe the property manager is feels like they're being attacked, and therefore they're acting on the defense. There are so many circumstances that arise as a result of that. Anything else? Hold on. Board issues. Under what circumstances, if any, can emails between one or more board members regarding board issues be considered private? I would say that if you want it to be private, it needs to be with an attorney present, with an attorney on the email, not third party. So you want to have the board members, attorney, maybe manager on behalf of the association, but you want to maintain that attorney-client privilege communication, and it should be regarding pending proposed litigation or a legal question or something of that nature. Anything else really is day-to-day operations. That's why I always say be very careful what you put in writing, because you never know when it's going to come out. And I've seen it where board members are communicating via email, just as you would expect. And they say something, their opinion on someone, and now they're publishing something that may be false. Maybe they didn't realize was false. Maybe it's not their opinion. Maybe they stated in such a way where now it's slanderous and discriminatory, and somebody else was on that email chain and got it out. And now you have a lawsuit for discrimination, or for defamation, or for slander. And you want to try to avoid that. Any feedback on that from you guys? I'm just trying to go through these. How can you have an email with the attorney when the board is not allowed to contact the attorney, only the president and the manager? So that's a situation case by case basis. So this is something where sometimes it makes sense for the board to appoint one legal liaison, right? Because otherwise you're going to have all the board members that are contacting the attorney asking for the same thing, or maybe for questions that are not appropriate. So either you stream it through the manager or through a legal liaison, and the goal would be for that legal liaison or the manager to come back and communicate it with the board members. I know it doesn't always work that way, and not every operation is perfect, but that's why that's implemented various times. And it works most of the time when everyone's doing their obligation on their end of communicating to the next person in line. But when I'm in email chains with managers and boards, and all of a sudden there's 20 emails that day and everyone keeps replying, and then someone changes the topic and now they're talking about their vacations and they forget the attorney's already copied, that's not fun for me, because I get hundreds of emails every day. So then having to figure out which one's important and which one isn't, you just have to be cautious of what you're saying, who you're emailing, and who does have the authority to contact the association's attorney. What is the purpose and power of the DBPR?
Oh, wait, sorry. Go ahead, answer that one, and then I have a question for you. I totally had myself wondered.
Oh, that's okay. That's a great question. It's in the statute. They have certain jurisdiction over certain aspects. It's too much to go into, but ultimately, I would say for an association to be aware of, they can enforce certain administrative code requirements. They can fine the association for violation, failure to provide records, failure to hold board meetings. They can fine, and there can also, when they investigate complaints. So there could be certain types of complaints that can be made to the DBPR. And then the DBPR also has an arbitration division. The arbitration division deals with certain types of disputes, and it has to qualify as a dispute based on the statutory requirement in the statute. And then the DBPR has jurisdiction over the dispute. For condos, it's broader. For HOAs, it's only, and for co-ops, it's really only for election and recall disputes. So, and they're going through a lot of changes there too, a lot of personnel cuts and different things. So they're way behind. And depending on the investigator or the arbitrator that you get, your issue may be resolved in a month. And sometimes it's still a year, and I can't get the investigator to respond or to determine the issue. So unfortunately, I wish I had a better answer to that. Ashley, what was your question?
I'm on mute. Okay, here we go. Is it legal for board members to email back and forth on issues that arise, as well included management company? Can we vote by email to approve issues without having a regular board meeting? What issues can we discuss without a board meeting other than an employee issue, compensation, or legal?
Okay, so you can discuss any issue via email with your manager. Again, be careful what you put in writing, but anything can be discussed via email. The law says you cannot vote via email. So what I recommend is get a consensus of everyone's opinion on the issue. And this is a kind of thing where you're fine if you isn't, when I say you, if a board is having to get together very often to approve minuscule items, they may be able to delegate that responsibility either to a committee chair, to a specific officer. So it depends on the activities of the association. If there's a lot going on and you can't be coming back to a board meeting to approve everything, then you need to delegate that responsibilities to specific members. And you need to make sure that, or specific committee members or specific board members, I'm sorry, not members of the association. Although sometimes you have volunteers, you just want to make sure that whatever is delegated, whatever is done is memorialized in the minutes. And I know it sounds like more of a hassle to make the board meeting than just say, okay, let's go ahead and, hire that landscaper. We need to change landscapers. You need to have it at a board meeting because you need to justify that a majority of the board members approved it. You need to have the minutes and memorialize it. And the statute requires that you make board decisions at a board meeting. So ultimately, you don't want to be voting via email unless it's absolutely necessary and is something that can be ratified after because of the time-sensitive nature of it. So,
and can you ratify it via email?
No. So you want to ratify it at an open board meeting. I mean, every contract, I would say as a general rule, every contract should be approved at an open board meeting or ratified at an open board meeting. For instance, in the management scenario, sometimes you're negotiating a contract with the management company that you need to have a closed board meeting with legal there, or you've agreed to terminate a management company and hire a new one, but you can't do that in the open yet because you don't want your current management company to know that they're being terminated and that a new one's coming in. So that's the type of thing that you do, maybe via email. You agree, okay, we're all agreed, we're going to go with this one and terminate this one. Let's schedule a board meeting to ratify it, but for now, let's go ahead and give legal the approval to start drafting on that letter of termination. Let's go ahead and ask the new management company for a contract, and let's go ahead and start getting our records from the old management company so that when we get to the transition phase, we're all set up. But you don't want to be, other than specific circumstances like that, I just do it in the open, do it at a board meeting. Now with Zoom, it's so easy. You can have your association get a Zoom account and schedule the board meeting, have the board members on, and get your decisions done. I had a seminar not too long ago about how to have an effective board meeting. And if you guys have, I think it's posted on our website, but it's really important to make it effective. You should have timed ideas of how long you're going to spend on each item. You should have the board members review the contracts that are being approved prior to the board meeting. Ask the specific questions that they have concerns on prior to the board meeting, so that when you get to that board meeting, you're going through those agenda items and banging things out, and the owners know what you're doing. They have the opportunity to chime in and to answer their questions, but the board members are on the same page because they've been discussing it. They reviewed the contract. They reviewed the estimate. They know of the owner issues that are going to be discussed. I mean, they're aware of it. A lot of the problems arise when board members show up to a board meeting, they haven't read anything, they don't know anything, and then every issue that comes up, you're spending an hour on because you're filling in those board members that have been MIA. So,
Alessandra, I think that's key, what you're saying, to running an effective board meeting, because that's when you run into these scenarios, like you're saying, where you're having a 3-4 hour board meeting or multiple board meetings per month, because you can't get through an agenda because you're taking an hour on one agenda item because the board wants to discuss everything openly. Now, we do want the transparency, but like you said, take the opportunity to ask the questions that you need to ask via email, get that feedback from your board, from your manager or the respective vendor beforehand, and immerse yourself with that knowledge. That way you come to the board meeting and you're ready to make a decision. And if you do have to ask questions, that's great. But spending an hour on an agenda item it's time consuming.
No, and it takes away from the fact that you guys, the board members are volunteers. They have their own lives. If they've already reviewed everything and they're ready to vote, and now they're having to go through and explain everything to all the other board members because they haven't bothered to look at their email for the last month concerning any association matters, you're not going to get much done as a board. So at the end of the day, and I saw a question here about guidelines for conduct. So, while it seems obvious, I do recommend, if there's a board that's having issues or concerns about board member conduct, that you establish a code of conduct. It's not that you can remove a board member because of failure to comply, but you establish, again, the expectations. The board agrees to review the agenda and the items provided by management prior to the board meeting. The board agrees to treat everyone with respect. The board agrees that certain matters are confidential and they're going to abide by it. The board agrees to disclose any conflicts of issues. I mean, all these things, yes, by statute, you have to disclose a conflict of issues. Yes, you should be, and we'd expect someone that's running for the board to be on top of what's going on, but having it in a 1 or 2 pager that they sign when they get on the board, acknowledging that those are their responsibilities, really establishes the scenario moving forward and what's expected of them, and they're fully aware of it, and anyone that wants to run for the board in the future will be aware of it. Oh, I see a lot of random questions, which could be, I think, seminars in and of themselves.
Definitely.
I mean, about the building non-smoking, that could be a seminar in and of itself, and you probably could, but you need to go through certain amendment procedures. Gary, did you answer the one about the 40-year certification? Are you typing that?
I think I already responded to that one.
Oh, okay.
I have a question here.
Yeah.
What are the logistics when an owner asks for email communication besides contacting their counsel?
Well, definitely, if a board member, an owner asks for email communications, then we definitely need to review the communications to make sure there's nothing that is privileged that's stated in one of the communications about pending or proposed litigation so that we can redact it. I always recommend to the board members, create for each board position a Gmail address or a Yahoo address. President of blah, 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 HOA@gmail.com. Vice president, secretary, treasurer, director 1, director 2, so that there is continuity, that those emails pertain only to association business, so that when someone asks to inspect those records, you can just go on and you can print them, right? It's all there, the communications are there. I would still recommend sending it to the attorney to review to make sure there's nothing privileged, but at least it's not mixed in with your individual communications, with your own emails, or maybe you're emailing with a board member on non-association stuff and you mistakenly print that out. I mean, there's so many issues that come out of email. It's still a little bit unclear as far as the law goes. There's been a few DBPR decisions on it as far as whether manager communications are records of the association. One of the arbitration cases went back as to whether or not the computer where the manager had those communications belonged to the association and was in the management office, or whether it was a manager's personal computer, the logistics of getting the emails, how far back it went. But there is no really clear guidance as of now. So definitely reach out to your counsel, because depending what the emails pertain to, the ability to review them may be limited.
Alessandra, go ahead, I'm sorry.
Oh, no, go ahead.
What's your opinion on the content that should be in meeting minutes? Are you of the opinion that it should just be motions, or do you think, are you of the opinion that, every single detail that was discussed on that agenda item should be in the minutes?
No, so very much follow the agenda, motion, second, approval. If it's a pertinent project or pertinent discussion, maybe a quick little summary of what was approved so that you can refer back to it. But and if the motion is not very specific, but no one wants to be reading a 5 pages of minutes of what all the commentary from all the owners. And also it's a liability. He said, she said, you're now putting it on paper. Maybe you misinterpreted a comment. Now you're distributing it to people. It becomes part of the records. Maybe a board member said something they shouldn't have. Maybe it just, liability reasons, simplicity reasons, and record keeping reason. I like to keep it simple. I don't think that it's supposed to be a play-by-play of every board meeting. But again, and every association is different. I mean, some of them do like to have a whole essay for every board meeting because the members expect that. Maybe they post it on their website and they've been doing it for so long that they want to keep doing it. But I just be really careful with anything that the board or the association puts in writing and distributes. Always run that by counsel or by your manager. If it's the minutes, check with them to make sure that it's accurate, and tell your manager. I mean, this goes back to the whole relationship. If the manager is doing their minutes in a way that the board doesn't like it, they need to communicate, because other ways no one's going to know. So should board members offer their opinions on issues in open meeting rather than just voting? It depends what their opinions are. I like to take the position, and I don't mean that in a bad way, but I like to take the position that the board should be unified when they get up there. They can disagree respectfully, but they shouldn't show so much conflict in front of the owners, because while they may disagree and discuss those detailed disagreements, outside of the board meeting, that shouldn't be happening where they're screaming or disagreeing or bringing up circumstances at a board meeting where you completely stray away from the topic at hand. And I see that that's what normally happens. So, and that goes to the next question: is consensus via email the same thing as an unofficial vote? Yeah, it sort of is, but you're still taking that vote at a board meeting. You're just making sure that you know how everyone's going to vote when that vote comes up. Obviously, they're open to change their vote because it wasn't official, but that's why you want to have the consensus there to make sure that everyone's in agreement before you take a certain action if you can't get to that board meeting. Gary, are you still there? Or are you connected?
I am. I don't know why there's somebody else with my name connecting.
It's your evil twin. Okay.
That's weird.
Is there anything else left on the slides?
No, sorry. I was just trying to get through the questions. And now I lost this. There we go. Hold on. So I think that's it. I'm sorry if I didn't get to all the questions. There's a lot. Some were not easily answered, so we weren't able to respond to them, but we did answer 91 questions.
Good. And more, I think, because I just missed some of them that I had answered. But just all in all, we are going to have a video. It will be up, within the next few days, and it will be emailed to all of you as well. So you guys can refer back to it.
Great. Thank you. So if anyone has any questions, please feel free to reach out. And there's no certification that's going to be mailed or anything, but thank you guys for taking the time to show up to learn a little bit more. Thank you for Affinity for partnering with us and for helping make this happen. And I look forward to doing another one of these soon.
Thank you, Alessandra, for having us. And thank you everyone for joining us today. We hope you learned a thing or two, and we'll see you soon.
Great. Thank you.
Bye, everyone.
Thank you.
Bye-bye.
Why is there two Garys here?
I don't know. Okay, I'm going to end this. Bye, Gary.
Bye. Take care.